I would like to offer an acknowledgement of country and a short discussion on what the acknowledgement of country is, because we do have some international guests with us. So in combined meetings in Australia, we acknowledge the First Nations and Indigenous occupants of the land and the elders who had custodian of the land prior to our time here. We have people dialing in from all over the country, but I am dialing in from Sydney, which is Gadigal land. And it's important that we are aware of and we acknowledge the traditional ownership of the lands that we are in. So I'm going to pass back to Fiona to conduct a proper introduction of our speakers. And just quickly, Fiona, are we about to start recording? I think we should make notification of that.
We have started the recording. Yes, thank you for that. So just a couple of housekeeping things. Thanks to Ryan for that lovely introduction. But before I introduce the speakers, I've just got to cover off a few things. So we've got a big group today. And as I say that, can I just get everyone to mute themselves, please? It will just make things a lot easier for our speakers. As we are quite big, we're going to reserve all of the questions till the end, where you'll get the chance to either put up your hand and ask your question, or you can pop it into the chat, and we'll get to try and get to as many as possible. So just so you know, this session is being recorded, and we'll try and make it available on our website in due course. And of course, keep an eye on our socials for more information about that. Just so you know, the IFE takes no responsibility as to what is being covered in today's session, and we have the full disclaimer there for you. I also wanted to take a moment to acknowledge that what we're about to hear will include some harrowing accounts of what is a tragic event. If anybody is affected by what you hear today, please feel free to either reach out to myself directly or to services like Lifeline or your own organisation's EAP. Okay, folks, let me introduce our very first speaker, Tom. An established member of Weightmans' professional negligence and insurance disputes team, Tom is based in the UK and represented the Risk Assessor during the Grenfell Inquiry. Ranked as a Tier 1 rising star in the Legal 500, Tom is known for his calm, methodical approach and excellent client care. Specialising in complex construction disputes, particularly post-Grenfell cladding claims, he's the go-to name in this field. With a growing practice in building safety and regulatory work, Tom handles everything from public inquiries to regulatory prosecutions with ease. Let's give Tom a big thank you for joining us in the middle of the night, as it's about 1 AM UK time. Our second speaker, Luke, is a local Australian lawyer and most likely a bit more awake. With over 3 decades of experience in commercial litigation, construction, insurance law and insolvency, Luke has seen more complex disputes than a prime-time courtroom drama. Specialising in claims from design and construction contracts and representing everyone from insurers to contractors, if there's a construction dispute, you can bet Luke has hammered it out. With recognition in the Australian edition of Best Lawyers since 2020, Luke is a true dispute resolution maestro. This dynamic duo will reflect on the Grenfell Tower Inquiry's Phase 2 report, providing an overview of the key findings and recommendations impacting the fire safety community. They will share thoughts on potential impacts of these recommendations affecting the fire safety management internationally, including here in Australia. So sit back and get ready to be enlightened by Tom and Luke. Thank you, gentlemen, for joining us.
Well, good morning, good afternoon, everyone. That's quite the introduction, so welcome to your disappointment that follows. I think, look, it's right that I start with a caveat, in the sense that there is absolutely no way, without keeping here for 3 weeks, that we can cover everything related to Grenfell. And I won't try. And since the second report, there's sort of been 2 approaches to commenting on it. The first is to try and offer the comprehensive guide, which always strikes me as a little odd because the summary report was 1,700 pages. We tried to condense it and managed to get to 60, which would still take me here for too long. And then the other approach is to somehow pick some hole in it, find a niche that you can hang your hat on. And it seems to me that it's a little cynical and B, not very helpful. So what are we going to try and do today? Well, look, I'm going to just start by offering you an idea. And I think the best Luke and I can do for you is to, in some way, give you some questions that you can walk away from to start discussing this. Because as I see it, it's certainly a journey I've been on quite intensely for 7 years. I think we got the call the day after the fire happened. And it's been a fairly rollercoaster ride since then. And it's certainly from my perspective, it's nowhere near finished. And so let me start with this idea. I heard someone say in the middle of the COVID pandemic that when it's foggy, you navigate as far as the fog lights show you. That's perhaps a more useful UK analogy because you probably have less fog than we do. But the idea that when there's mist or that somehow you're driving, your visibility is impaired, all you can do is really navigate as far as you can see. And I've sort of come back to this time and time again with this building safety stuff, because I think that's basically where we've been on. We've had various events and it's added a degree of fog or complexity to the way we thought we understood the world. And really, all we've been trying to do is understand what does the next bit of the journey look like. And if I can torch the analogy a little bit further, I think there was a sort of a groundswell shortly before the report in September that seemed to work on the assumption that somehow, as you know, the inquiry team were going to report, and this was somehow going to lift all the fog in the room, that we were somehow going to get clarity, that we were going to see the light, and that all would be made clear. It seemed to me at the time, and still does, that was an entirely unrealistic expectation, not least because public inquiries in the UK are not set up with the power to achieve that, even if humanly they could. And so for me, that it's more like, if you will, you're journeying along a road and you're not quite sure where you've gone, you're not quite sure exactly where you're getting to, but you meet someone local, someone who's got some knowledge of the terrain that you're traversing, and they explain to you a little bit why the journey was so rocky up to this point, and they give you some pointers of what you're likely to see ahead. But it's not like having a GPS or a map that's going to direct you exactly the route. And I think I'd like you to take that away and perhaps use that to filter your discussions, because very much as I see it, and the clients I work with, how they're seeing it, is that that's what we're going on. The report's come out and it's given us a narrative to explain how did we get to the point where in 2017, in one of the richest parts of the UK, 72 people died in horrific fire. And it's given us some sense, looking forward, of where it's likely to go. But we and you and your contemporaries around the world are still left with a slight uncertainty of what do we do about it. And it's fascinating to me that my own practice, that in 2017, it was sort of round the night work on the inquiry and claims. And of late, my practice has transitioned more into more advisory capacity. As clients are starting to ask these questions of, well, I don't know what I need to do, but what do I do in the interim? When this sort of purgatory period, what do I do? So let me leave you with that. Let's just have a recap. I'm sure this is all familiar to you. If we have the next slide, please. So Grenfell Tower is not in many ways a particularly unique tower. I've had the, I would say, dubious pleasure, but it's not really a pleasure. It's a terrible privilege of walking up and down it after the fire in a hazmat suit. And it underneath the external cladding, it was an old concrete building, fairly simple construction, single stair down the middle, some quasi-commercial public spaces at the bottom, and residential flats, a whole community living there for many years. As part of, as we all know, sort of 15 years ago, slightly more perhaps now, we have this worldwide focus on our energy crisis, and we drastically look to insulate our buildings to make them more sustainable. And along come these wonder products, ACM cladding, various forms of insulation, various other forms of materials that we whack around the sides of buildings. And there's also for the more aesthetic in the room, there was at least some that believed that it made some of these horrible concrete buildings from the 60s and 70s look slightly more attractive on our skylines. I query whether or not that was true in this case. Ultimately, in the saddest of events, fire breaks out in a fridge. If anyone ever was really bored at night, the report on exactly what happened in the electrics will send you to sleep. And fire traverses through this very small kitchen. And what should have happened is it should have shot out the window, and it should have come back on the outside of these aluminium clad panels, and it would have slightly dispersed across them, but they wouldn't have largely propagated the flame. And the fire service would have come, and we may have seen some traversing of the fire into the neighbouring flats, but that was what was expected to happen. What in fact happens is that due to the nature of these materials and the way in which the build-up was designed and put together, fire not only goes out of the window, but it also goes through the side of the window frame construction and essentially into an unstopped cavity. And fire then moves in a way which the fire service did not expect it to happen. And it's for another day. There's some discussion over whether or not the knowledge was there, but essentially fire moves far faster. And so the fire service are behind the curve from the start. They simply can't pump up enough. They can't get enough people on site. Fire shoots up the side of the north side of the building. It hits this architectural facade around the top, and essentially it goes off like a firework. It just spins around the outside because the materials itself burns and then entirely uncaps at the top. And then the fire does what is the industry least expected it to do at the time, which is it starts descending downwards. And so you essentially have a building enveloped in flame. Now, it's perhaps a slight mercy, I think, that in the final report that they concluded that those who died in the tower largely died from asphyxiation from the pollutant gases that were borne off. And whilst people were ravaged by fire, that the belief from the experts is that mercifully that was not the cause of death. But in any event, it's a horrific setting, and I can tell you from first-hand experience of walking around it, it's a bizarre experience. For anyone who's interested in films that are filmed in London, you'll go past all these very, very recognisable landmarks and very rich area, and then it's just absolutely ravaged. And I've put this cause where we've got the materials themselves, we've got the way the materials are used together, and that's a huge part of it, a lack of understanding about how these materials intersected. And also this huge lack of knowledge, which did exist in part, or in some places, but simply didn't make it through. And as a result, what you have and what we've seen happen across the globe is that we start to have a major rethink. Absolutely right that we do. And you saw this replicated in the inquiry. For those of you who don't know, public inquiry is the way in which the government in the UK set up this sort of tribunal. It's not an official court in the same way. Some of the specific legislation, there's usually a retired judge who's in charge, and they have quite wide-ranging powers to investigate what's happened. And so beyond the sort of usual court process, they will have much longer, and this took 7 years, unbelievable, but they will get into the detail. But they don't ultimately decide responsibility. And so that's quite important, because what you ultimately get is a very detailed account of what happened and what was wrong. And you have some suggestion as to why it was wrong, but it can't quite go that far. And the reason that's important, and the reason I think this is, if you like, distorting the discussion following the report, it is again to that point of the expectation that was put on it. People expected to find out who was responsible, why they were responsible, and then be able to do something. But the report, as you would imagine from the very large number of senior lawyers who were engaged on it, is very carefully worded, and so it's not always obvious or particularly well defined as to two things. One, what is specific to Grenfell, and I would suggest, certainly from my standpoint, I must admit that there is there are certain factors which are Grenfell specific, and then what is actually wider, what's systemic, what do we need to take away and learn as an industry, as much further afield. And because it doesn't give you nice headed paragraphs saying this is the Grenfell conclusion, this is the wider conclusion, we're left in this position prior to governments and prior to courts engaging with it, of having to work out, well, what does that mean? And I suppose just to go on, the reason why I think there is something that's Grenfell specific is, I'm sure Luke will touch on this in due course, that there have of course been fires around the world. There are a number in Dubai, there have been a number in Australia, but the difference is that 72 people didn't die. And so there is this question of, well, what was different here? And yet the inquiry merged very quickly. For those of you in the fire service who may have seen it or been interested at the early stages, the initial investigation started at the fire service and their response. And the poor watch manager who was initially in charge of the response on site was on the stand, I can't remember, it was 4 or 5 days. And it almost, in that evidence, for those of us sat in a very crowded room, it almost became clear that the inquiry was necessarily going to have to go much wider. That this guy just simply, whether the knowledge was in his institution or in the industry, he simply wasn't in a position to understand it, and that creates some interesting questions for us. If we go on to the inquiry, we've got a little slide here. I'm not going to try and go over it. Just to give you a sense of the scale, the initial phase, there's 2 major phases, and they were all subdivided. The initial phase basically looked at what happened and why in a very limited sense. So why did fire break out? Why did it propagate in the way it did? And the conclusion was rather frustrating to us as lawyers, because the lawyers, we like a good reason, because that gives us some arguments to basically help our clients distinguish it. But what the esteemed judge in charge of the inquiry concluded was that it was so manifestly non-compliant that there was no way on earth that this building complied with relevant regulations, that for want of a better phrase, he didn't have to bother explaining to us why. And so we all ended up exhausted at the end of phase 1, thinking, well, that was all very helpful, but not very useful. And alongside that, in the UK, Dame Judith Hackett, long-standing in the building industry, conducted her own review, which, from the limited, I will say, knowledge I have, was similar to some of the reviews that happened in some of the states in Australia, particularly in Victoria. It was a much more technical, short, sharp, this is our reflection. And this creates this funny dynamic where she suggested a new way forwards. And then the government spent a very long time trying to enact what they called the Building Safety Act, which essentially enshrined her view of things. And my other great source of work is that it's terrible. And so trying to work with clients to engage this piece of legislation. And the reason to me that's not surprising it's terrible is that we've not got to the end of the investigation. We sort of had an initial gut reaction and we enacted some legislation. We've tried to work it out, but there's very much the sense of the new regulator trying to get to grips with exactly how does this look and how do we want to build buildings going forwards. We then, everything got slightly sidetracked by COVID. If I ever meet any of you, I'll tell you some of the bizarre stories about the inquiry trying to navigate the restrictions, including taking a temperature on the way in, but then taking a mask off in an air-conditioned room, all very bizarre. And then it all went sort of rather from public inquiry to behind-the-scenes inquiry. And also at the same time, that second phase went into a lot of the detail. So I acted for the fire risk assessor, who I appreciate isn't particularly a profession in Australia. It's questionable whether it's a profession in the UK, but it's largely members of the fire service who come up to retirement age, largely been involved in the side that is in the inspection regimes and the fire safety assessment side. And they go into private practice and they conduct these reviews in line with a piece of legislation, some guidance. And the whole idea of it was to give you sort of a snapshot in time as to well, what's the state of this building, and to give you some action points to take away from it. So I represented them. We got into various, and it started to get slightly bizarre because you get all these different experts coming up, and everyone, of course, has perfect vision in hindsight, and everyone has a different standpoint. And I think one of the key takeaways and this was borne out in the conclusions of the inquiry, was this lack of coherence between different industries. That you have lots of different players enacting their roles in relation to the safety of buildings, but not necessarily in conjunction with others. And so you might have fire risk assessors assuming that the fire services, what the time called Section 72D visits, but visits that they conduct on a regular basis. If you do the same thing, but would get the fire service supposed to go around the larger, more complex buildings and keep logs of what's going on. Fire risk assessors would assume that that was understood and communicated. The fire service were assuming that the fire risk assessors were doing that. Fire engineers were taking fire risk assessors reports and assuming that they had some kind of long-term vision, whereas fire risk assessors were assuming that they were a snapshot in time. And then all of these were then feeding into the design of buildings. So then we then end up in September this year. We finally get the report. It's 1,700 pages. In their wisdom, because the first stage report got leaked, I think within an hour and a half, the inquiry gave those of us who acted on it an advance copy for all of 24 hours. And I don't remember anyone who isn't a lawyer trying to read 1,700 pages in 24 hours, but it was not enjoyable. But clients were on the phone the next day, and so sadly, this is not the first time I've been up in the middle of the night. If we go to the next slide, I've put here, this question about whether or not this is the perfect storm, and this goes back to this point about what's Grenfell specific. And I remember being sat in the inquiry in one of the early stages, and an incredibly intelligent and also emotionally intelligent barrister who's representing one of the cohorts of the bereaved survivors and residents. So these are the people who were in the tower and survived, or the family members of those who passed away, or in the local area. And he submitted an inquiry that it was essentially untenable to reach the conclusion that this was a perfect storm. That it would be a disgrace to the memory of the people who died to conclude that. And I think what he's essentially saying is a slightly lazy conclusion, that the inquiry wouldn't have done its job. And the inquiry doesn't, in those words, conclude that. But if you take it in the round, that is largely what was the case. That there was, I put 3 years of failure, but decided there was institutional failure. So failure in the development of regulations for 50 years, failure in the government's response to managing previous fires, failure in the industry in terms of the dissemination of knowledge. And there was knowledge about these products. There was knowledge about the way fire operated when it came to contact them, and it just didn't pass through. Sometimes by nefarious means, where particular manufacturers had sort of circumnavigate testing houses and the like, but also sometimes just by the nature of professional business, that life's busy and it simply didn't pass on. And then huge criticism of specific professionals. And that's a wide range of things. And I think it's quite hard to not conclude that in Grenfell itself, at least, there was this perfect storm, that there were so many faults. And it's right that in due course, when the criminal action's complete, that people will be held account for their own specific part in that. But at the same time, it leaves you with this slightly difficult, perhaps, conclusion that this was the case. And as I said earlier, the inquiry doesn't allocate responsibility. And so, as we'll see in a minute, in regards to various professions, they gave fairly staunch criticism, and perhaps, I think, harsher than many of us who were close to it felt they would do. But it's unguarded, it's undefined. It doesn't specify as against other professions. And so you're left with this position of saying, well, I'm not quite sure what that means going forwards, or I'm having to work quite hard to understand what that means for me. So just by way of an example, which is close to some of you, and I think the position is probably similar, fire engineers, and this will be relevant to those of you in that particular profession, but also those of you in the service who will interact with the outcomes of what fire engineers do. Exova, at least at the time, thought it was a very credible, large organisation. They come across in lots of projects I deal with, which is not always a good thing. And they made some of the issues that the inquiry identified was that they made a lot of assumptions, that they use junior staff. Big organisations do, don't we? And they use limited source materials. And what they really were saying was that they had a particular view of how they were acting, and they saw themselves as a secondary player. And interesting, another part of it was that they didn't consider external facades. And a big part of cladding litigation over here, and Luke's views on it, but there's been split view about what do you do when a fire strategy report doesn't cover facades. Is the default position the building regulations as it is here, and that sort of highlighted this wider issue, which is there was a split of understanding about when you engage a fire engineer, were they expected to cover the whole building, or were they only really engaged to deal with those parts that don't meet the sort of underlying assumptions of the regulations, or were they only engaged to comment on the bits they were asked to? And I think a lot of us were surprised, if we go to the next slide please, about the criticisms of the fire engineer, because the inquiry didn't spend an awful lot of time, as they couldn't, looking at what was the practice generally. But I think there is certainly a body of opinion which suggests that Exova didn't act particularly unlike its peers at the time. And for those of you with any legal knowledge, certainly over here, the test for professional was, were they acting within the standards of the regional body of their profession? And we've yet to consider whether or not they did, but they were certainly under criticism. And it's hard to see how that won't, when the courts consider their role going forward, it won't have upped the bar. We just have the next slide, please. I think one of the things to look out for is that I suppose two factors here, and it will be interesting, obviously, as you as members of the IFE, because I think the IFE will be the prime candidate for dealing with this going forward. Obviously, IFE, the way it certainly operates in the UK, it's not mandatory regulated. It's not a statutory requirement. So unlike architects, certain engineers, lawyers, accountants, where we are required to be regulated, there's a degree of voluntary, albeit in recent years it's been more a case of the assumption is that you won't be employed on a significant project if you're not past the IFE. But one of their recommendations is that they will have a lot more specific regulations. So it's certainly something to watch out for. And there have been other professions, so private building control, so those who inspect buildings sort of on ad hoc basis through construction. We've seen that they have become vastly more regulated, and I think we'll see a similar thing with the fire engineers. And there's, from my work, one of the things we were saying throughout the inquiry as well, there is no real regulation or mandatory regulation for fire risk assessment. And one of the recommendations is that becomes the case. And so again, watching how those regulatory regimes develop and how they develop with each other. The inquiry and the recommendations designed a scheme that has a centralised regulator. I mean, in the UK, we're all bankrupt, so I don't know how they're going to do it. But I think that in theory that would work, because you would allow the regulation to sit side by side. I think in reality, existing institutions will be leaned on. And whether or not that deals with that lack of coherency between professions, or whether or not it just proliferates it, I think remains to be seen. Another thing to look out for is that Exova operates, I would call it a sort of call-off basis. So they did what they were asked to do when they were asked to do it. They weren't particularly inquisitive, and for some of you that might be professionally difficult. You may think, well, as a professional, it's sort of incumbent on me to be inquisitive. That they weren't, and I think there's definitely some scope in terms of how the recommendations are enacted as to whether or not the obligation, or what a reasonable fire engineer is expected to do, requires them to go out and look for information, to request it, and if they don't get it, to chase it. And another key thing was in terms of their contractual position. And what we've seen is a lot of these sort of what we might call emergent professions, an understandable lack of knowledge about how complex construction contracts work, and quite what the extent of their obligations were. And the inquiry rather suggested that it was incumbent on them to find out, and also to see it through. And so if you took on a contract to ultimately perform this all singing, dancing fire engineering report, that might go through various variations through the construction phase, actually your expectation was you should do that. Now that raises questions. What if you're not paid? What if you're not invited back on site? What if you're not actually, as often was the case, people would sign up a nice retainer with the fire engineer, get an initial report and say, thank you very much. And we've got it through building control and we'll crack on. And then Jimmy, who's the site manager, will find the materials if we need it. I'm being a bit facetious, but that's the sort of, I think that's going to be a really telling point. So the final point on that slide was this idea that they had considerable responsibility, and that conclusion was levelled at a number of professions. And so again, back to this point of it was considerable. I can't possibly begin to explain to you what that means. And that creates, again, Grenfell, because this is for perfect storm, it's almost the perfect example to deal with a portion of risk, because everyone was being criticised. And so in many ways, it would be the perfect example for lawyers in the courts to look at it and say, well, where everyone's at fault, here's how the percentages line up. And much of the litigation, which on a human level, I think is a good thing, has been settled. And we've been working hard at that for some time. I think there were about 1,700, 1,600 claims in the ether at one point. They've been vastly reduced. I hope, for the sake of those involved, that they are ultimately settled, because this sort of litigation never gives people what they want. But we will also never get, I think, this opportunity to work out. Very quickly, you'll have the slides. The next slide we can skip over. The key issue recommendations, but they're largely matters that I've turned on, other than to essentially say, I think in the UK at least, I'm interested to expand that, you'll see a more formalised role for fire engineering, and you will see a greater level of engagement, responsibility. For those of you involved in the construction profession, something to think about is costing projects up going forwards, and how you actually assign money for that. Because if I was advising any fire engineer based on what the recommendations say, they would suddenly become a lot more expensive to engage. So there's a little practical thing for you to think on. And the final slide for me before I shut up, where does this leave us? I think in due course we're going to get greater clarity around fire engineers, and I think we will get greater clarity about what the different roles of those operating the fire safety profession. And for those of you in the services, I think certainly in the UK we will also see greater responsibility for the fire service, and I think that can only be a good thing. Whether or not we get the buy-in from necessary professions, I don't know. From talking to people, I think there's a lot of concern about it. All sounds great in practice, but have you ever worked on a construction site? And I think that is just so it's to be wrestled with, and whether or not in the UK at least the government are bold enough to make big changes remains to be seen. But who bears the cost? One of the great ironies of Grenfell was that I think the value engineering exercise saved it was a couple of £100,000. So in the scale of things, a very small sum of money, and the inquiry alone cost tens of millions just to understand it. And there is a perversity in that. Anyone who's acted with clients in this space, these recommendations would add, I think, tens, hundreds, millions of pounds to lots of projects. And there is a question about how do you do that, and how, also in terms of, we're having plenty of debates, often quite academic at the time, about different types of buildings. What's relevant for what stage buildings do you start introducing some of these requirements? What do you do in the meantime? Going back to where I started. Well, I think when people ask me that question, all I tell them is, again, you're back to navigating the fog. I mean, you can only look at what's likely to happen. If matters, and Luke will speak to this from his perspective, if matters go the way they are, I think you will see increased regulation in industries operating in this space. I think you will see increased expectations from the courts. And I think one of the other points we've not really touched on today, because it's a big topic, is the requirement for professionals to stay on top of developments in their industry. And one of the issues is that people just didn't understand these products. And I think that is unlikely to stick as an excuse going forwards. That probably requires increased training for you as an organisation, something to think through as well. What do we do in terms of developing our people? How do we stand to what's reasonable to do? Not everyone is going to be the world's leading fire safety expert, but in my profession, in my capacity, in my role, and I think the other learning from it was, gut feel is not the answer to all things, but it's quite important. And I guess my warning to people is always, if you're in a situation where you feel I'm being asked to go outside of scope, that I'm not really qualified to speak to this, that's usually your marker to stop and to work out who should be engaged. Because there were lots of people on this project who weren't really qualified, weren't really engaged, didn't really know what they're doing, tried to be helpful, tried to get the gig. And many of them are sat there having had their reputations dragged through the public eye for 7 years and facing criminal proceedings. Probably most are genuinely good people who are trying to do a good job but have rather left it. Anyway, I'm slightly over, so I'll stop there and take questions later. But over to Luke.
Thanks, Tom. Well, certainly there are a lot of parallels between what you've spoken about and the Australian experience. So Fiona, we might jump forward. Probably the next slide again. Yeah. So that's an overview of what I'm going to touch briefly on. The New South Wales response as perhaps the most far-reaching at the moment amongst the Australian states. But what's apparent is that in Australia, the government response to fire risks, which came out of the Grenfell disaster, has been tied up with residential building defects more broadly, and also the non-conforming building products and their use more broadly. And certainly after the La Crosse Tower fire and certainly after Grenfell, but all the states brought in particular legislative responses to manage polyethylene, combustible cladding, and to provide for audits of buildings. But as I said, the response really has been much broader in Australia, and it's been based on the need to restore a broader confidence in the local building industry. Next slide, please. So how did this issue become so important in Australia? Well, back in 2014, there was the La Crosse fire in Docklands in Victoria and Melbourne. It was a mixed-use building, 23 floors. A cigarette butt from a backpacker, I believe, sparked a fire. And there was cladding which encouraged rapid vertical spread. And that led to the L.U. Simon litigation, which we'll come to. L.U. Simon was the builder. There was in Grenfell in 2017. 2018 saw the Opal Tower in Sydney, which was a 36-level development in Sydney's Olympic Park. And it hit the headlines when it was evacuated on Christmas Eve in 2018, only 4 months after practical completion. And there were under-design issues, material defects, including in the concrete, and it was months before residents were able to return. And that sparked a New South Wales inquiry into the regulation of building standards and building quality, building disputes, and also a few class actions. The Neo 200 in Melbourne in 2019 was another wake-up call locally. It was again a cigarette butt on a crowded balcony in a 41-level apartment building. Rapid fire spread, and the shock which came out of this one was that despite the 2016 combustible cladding assessment, which had been undertaken on the building after La Crosse, that assessment had marked the tower as low risk when in fact it had similar cladding to what was on the Grenfell Tower. So that just showed up the continuing deficiencies in the monitoring. And then the Mascot Towers in Sydney was another high-profile building defect case. In Sydney, there were 2 towers. They were about 10 years old and beyond the statutory warranty periods. And major cracking in the structural concrete led to lengthy evacuations. The owners' corporation and the lot owners were facing $32 million in repair costs, as well as interest on a loan taken out on an interim basis. And I think most recently there's been an agreement finally reached for the lot owners to sell that building to be demolished and redeveloped. But they've suffered an awful lot of loss. So clearly damage to the public confidence more broadly. Next slide, please. The Building Ministers Forum in Australia is a body which is made up of the building ministers for each of the states and the Commonwealth. And in the aftermath of Grenfell, they engaged Professor Peter Shergold and Bronwyn Weir to look into all these issues, and those 2 people produced this building confidence report, which is effectively been adopted in principle by the Commonwealth and all the individual states, which, providing generally for class 2 to 9 buildings, and they made a range of recommendations. Importantly, constitutional and financial responsibilities mean that the Commonwealth doesn't really have power directly over many building issues, including certainly fire regulation. And whilst all of the states have agreed in principle that they're going to institute these recommendations and this framework, it's up to the states as to how and when they do it. And unfortunately, it is quite piecemeal, and some states are going more quickly and certainly further than others. Next slide, please. The report, that building confidence report, looked at fire safety and it identified these critical issues: the lack of a nationally consistent process for fire systems design, installation, certification, practitioner registration, fire protection systems. The fourth point there, that fire safety engineers were often engaged to prepare engineering designs that included complex performance solutions on critical safety matters, but their advice was not generally sought on overall fire safety strategy. It was really the building surveyor, or in some states called the building certifier, whose job was to inspect the complete building work, and the fire engineer didn't have involvement in that. And there are otherwise differences between the various states as to legislation and regulation. And they thought that certainly a stricter and more rigorous approach is warranted. Next slide, please. So this is the Building Confidence Report recommendation in relation to fire safety. So it's fairly short and sharp, basically requiring fire safety practitioners to design, install and certify fire safety systems necessary in commercial buildings. Now, certainly commercial buildings there is much broader than purely commercial buildings. It's basically anything these days other than standalone residential dwellings and some smaller boarding houses. Next slide, please. So the Australian Building Codes Board has published in 2021 the model guidance based on the Building Confidence Report Recommendation 19 in relation to fire safety systems. And it enunciated these principles. Basically, the government should be regulating installation, testing, independent certification and maintenance of critical fire safety systems in effectively all buildings other than buildings not intended to be inhabited, and standalone homes and small boarding houses. The second principle there, that installation and testing of systems is to be undertaken by registered practitioners. Thirdly, that certification of the installed systems is undertaken by independent and registered practitioners, and routine maintenance is the same and reported to the state or territory regulator on an annual basis. Next slide, please. This is a litigation that fell out of the Lacrosse Tower fire in Melbourne. And it shows an example of the complexity which confronts the courts, the parties, insurance companies in assessing and apportioning liability for building and product defects. So where a building owner does have rights to recover rectification costs against the builder or other parties involved in the building's construction, then assessment of liability and apportionment is going to be often a very complicated exercise. So in the Lacrosse case, the claimants, which is effectively some of the owners and the body corporate or the owners corporation, were claiming some $12 million for reinstatement of damaged property, additional insurance costs, which the fire and the cladding had brought about, and some compliance costs, including replacing the cladding, which, although not damaged, was no longer appropriate or were no longer legal. And the body corporate sued the builder, L.U. Simon, the building surveyor, the architects, and the fire engineer. Next slide, please. The tribunal there found that the builder was 100% liable because effectively on the basis of statutory warranties in relation to the building the process. But importantly, the court or the tribunal apportioned liability between the 4 other parties there and found that the builder was entitled to recover from all those other parties. Now, because the smoker was not engaged in the proceedings and presumably had no money, the builder was left hanging for that 3%. But the builder was otherwise entitled to be indemnified for the liability from the building certifier or building surveyor, 33%, the architect 25%, and the fire engineer 39%. So the court or the tribunal there said that given their level of qualifications and the nature of their responsibilities, it was fair to expect fire engineers, building surveyors, and architects in that order to have a better grasp than building practitioners of fire risks and the application to the Building Code of Australia of those risks. So as a rationale, interestingly, the fire engineer in that whole project was paid $33,500. So, I just don't see how it's sustainable to incur responsibility for millions of dollars, but when you're only, doing work of $33,500 on the project. Before Lacrosse, fire engineers had a limited role in construction projects with material risks really going to the building certifiers or surveyors. But now, if fire engineers are providing full fire engineering assessments, then that sort of work is going to be categorised by insurers as high risk. And you have to have a look under the Lacrosse ruling whether you've got an obligation to provide full assessments to proactively investigate, provide an assessment of the whole building for fire hazards, including construction materials, and not just areas identified by the building surveyors as presenting a high risk. So fire engineers more and more are expected to be product experts in the construction materials when it comes to fire risk, and the courts won't be letting them delegate that responsibility to surveyors or architects. Next slide, please. New South Wales, as I mentioned, is really the most aggressive in their response, and that probably reflects the fact that they had the highest profile building defect scares. They appointed a building commissioner who was very focused on consumer protection. That's the 6 pillars of their response. On a couple of them, as we'll see, particularly in relation to insurance, they've been pushing faster than the markets are able to respond, and particularly faster than the insurance market is able to respond. Next slide, please. In particular, New South Wales, they brought in, through the Strata Schemes Management Act, a requirement effectively after practical completion and when a building is occupied, for the developer to put up a bond equal to 2% of the build price, and that is held potentially for up to about 2.5 years after occupation, and that is meant to basically be as a security for building inspections for major defects during that period. That's created certainly a lot of tension with the builders, because usually the builder would have a 5% security out, and half of that would be released at occupancy or practical completion, and the other 2.5% would be released at final completion 1 year after, when the defects liability period is run. So you've got builders who are refusing to have their 2.5% security out for the extra 1.5 years. And you've also got the government at the same time in New South Wales looking to increase progressively that 2% up to 3% and, up to even 10%, with a view to making it cost prohibitive so that parties are basically, it's cheaper for them, the developers and the builders, to take out decennial liability insurance, which is effectively a 10-year defect liability policy for a building, which would cover all of those parties. Now, the planned increase from 2% to 3% was meant to happen early this year and then last month, and the government has had to defer it on both occasions because the insurance market simply isn't there, and the builders and the developers are not prepared to be pushed that way. Those other two, the Residential Apartment Buildings Act and the Design Building Practitioners Act, they're both directed towards identifying and inspecting residential or mixed-use buildings whilst they're being constructed. The RAB Act there, it requires the builder to give notice to the building commissioner of, within 6 months before you're expected to reach completion, and that gives the commissioner the opportunity to go out and inspect what might be risky or dodgy projects, or probably more risky or dodgy builders. The Design Building Practitioners Act brings in strict registration and adequate insurance requirements, requires builders to obtain from design practitioners compliance declarations in relation to the design and the building work and variations. So it's really quite a structured and more and more imposing regime which is being forced. And with the insurance obligations, particularly for the design practitioners under that act, again, that's one area where the legislation required simply adequate insurance, and they left it up in the air because the insurance market wasn't able to put in place the broader insurance which the government would want to mandate. So they've really just pushed that down the road a little bit more. Next slide, please. I've been talking about insurance. This is just a couple of examples where the Insurance Council of Australia made these submissions to the Building Ministers Forum, and to the effect that there simply isn't any product readily available in the market which responds to the certification process for a builder by a builder, and it's more akin to a warranty, which professional indemnity insurance is not intended to cover. So one reason there's been a blowout in the insurance is quite apart from claims over the last 10 or 15 years, but back in the 1990s, or before the 1990s, responsibility for building certification and inspection lay with the local councils generally, and they, that obligation was basically seconded out to the private sector, and that's brought with it a whole range of issues, including independence from builders, independence from developers, costs, insurance obligations. So none of those issues is going to go away quickly. Next slide, please. One example out of Victoria was that when the Victorian government engaged contractors to undertake some remedial cladding work, they simply couldn't get insurance for the work. So the Victoria had to spend $7 million to get them covered. And based on the LU Simon Lacrosse Tower case, consultants with a relatively limited role, it's an unfair outcome that they be expected to have responsibility for millions of dollars if they're simply not, they don't have that much skin in the game to start with, and particularly if they can't get insurance without significant exclusions or gaps in the cover, and certainly more and more with higher deductibles and premiums. So it may well be that the future lies in decennial insurance, but how close that is to becoming a reality, it's hard to say. Next slide, please. So I think the only certainty is that things are going to be more expensive. Improved safety is obviously an important goal in construction and looking at fire safety and fire services generally. So builders and developers are going to bear the immediate brunt of those additional costs, and I think the costs no doubt will be passed on to the buyers of the units or the property involved. And I think it's also certain that fire engineers will continue to be caught up in that financial tangle. So that was the end of my thoughts.
Wonderful. Thanks, Luke, and thanks, Tom. I'm going to open up for questions now. So if you could please use the little hand logo to raise your hand, and we'll go in order of that way, or you can pop your questions into the chat as well. We haven't had any questions yet, but I think Ryan had one that he was going to ask. Probably a very tricky one, knowing Ryan, to get us kicked off. Ryan.
Thanks, Fiona. Look, Luke, looking at the liability breakdown from the La Crosse fire, and as I understand it, it's essentially it's a building damage issue. But if La Crosse included some fatalities in it as well, would you see a change, or would you perceive that there would be a change in the breakdown of the liability? Obviously, how it was prosecuted to become a criminal case as well. But do you think there's some skin in the game for fire services too? And I'm thinking about that from the perspective of involvement in approvals when buildings are built and response. And Tom may be able to weigh in that with his view of what's happened with the London Fire Brigade and the Grenfell experience.
No, I think that's certainly an interesting and a realistic question. I think the starting point is that there's two main issues that jump out. One is that the liability for personal injuries claims or death claims in I think all states in Australia can be joint and several, and it's not something where proportionate liability legislation applies. So, for example, if you have some property damage claims and you're suing a range of different professionals involved in the project, then it might be that the builder, if he's found to be 50% liable, and the architects are 25, and the engineer's 25, for example, then the builder's liability will be capped at that 50%. If for example the engineer goes bad and you can't recover your 25% from him, then the builder doesn't have to make it up. So that's the proportionate liability regime, and that's subject to any contractual arrangements between the parties, but none of that applies to personal injuries claims. So in personal injuries claims, I'm sure a plaintiff lawyer would be looking to sue as many parties as they can, and certainly the insurers for the parties that have been named will be looking to bring in as many other third parties to share the liability. So I think certainly the inspection would be an issue. I wonder about the fire response. It's a question of causation and just how immediately the fire response might have caused or contributed to the death, and I think that would be a difficult question to decide. But generally, I think in the personal injury sphere, you'd be, the net would be cast much more widely than on the LU Simon case.
Wonderful, thanks, Luke. And what do you think's next, Tom, for the criminal prosecutions in Grenfell?
That was a good question.
Have you got a magic ball?
A long wait is the answer. I mean, I think the there was a high expectation on the recent report the Met Police, who were conducting the investigation, would start fairly quickly. They've said it's going to take them at least 18 months to go through all the process, and it's partly due to some fairly complicated arrangements between the inquiry and the Met, and various undertakings were given by our Attorney General as to what evidence could be used in which investigation and so on. If you want my sort of informal view, I think that there's going to be huge pressure for them to get a big scalp in terms of corporate manslaughter. And really what everyone's looking for is someone to primarily pin things on. So I imagine that what they will be doing is working out the right order in which to pursue these, and they will go after whoever they think that they can ultimately get on corporate or gross negligence manslaughter and be able to, or the number they can. And then I suspect that thereafter what you'll see is what some might sometimes be called the Al Capone effect, which is that you'll see people go down, but for odd offences, so fraud by murderous threat, or odd things that people have done, but they still get them on there. Particularly with certain respects where the legislation doesn't really allow suits people. But I wouldn't wait up for it. I think it will be a number of years, and based on our experience of other disasters in the past, it will potentially be quite some significant time.
Fantastic. It's definitely one to watch. I know I'll be looking at that, following that closely. So Ange, our Vice President, who's also a fire engineer based in Brisbane, has asked a question in the chat. Should we, and if so, when should designers engage with us? And if not all of the fire engineer, can we support it? Maybe that's one for you, Luke, in the local setting. You're on mute though, so just yourself off.
Sorry, Fiona, can you just read that again? It was cutting in and out for me from that end, sorry.
That's all right. It is in the chat. See it, and maybe Ange wants to take herself off mute and ask it properly. But her question was, should we, and if so, when should designers engage with insurers? And if not the role of a fire engineer, how can we support it?
Well, you need to be engaging with insurers before you're doing work, and that needs to be on an annual basis. And as I said, the main issues we're seeing are the exclusions on cover, which are going to be imposed by some insurers. The second issue is whether those exclusions are sufficient to enable you to comply with the registration and insurance requirements on a state-by-state basis. And then thirdly, you need to be looking at the type of work you're doing and the scope of the work, and whether it's just a particular issue or whether it's a broader, like systems-wide responsibility. And that needs really to be documented clearly in the contracts. And also, I think it needs to be explored, through your broker with insurers, because as I said, some of that sort of work is going to be regarded by insurers as more high risk and may not be automatically covered without additional premium or additional work.
Yeah, fantastic. Sure, the advice is when it comes to insurance. So fantastic. We have gone quite a few minutes over time. I haven't seen any other questions or any other raised hands, so we might call it a day for now. But a big thank you again to both Luke and Tom. An amazing, insightful presentation, a whirlwind, a globe, definitely a lot for thought. Is our first IFE Ignite webinar. It won't be our last, so at honing in on some of these more particular questions around faults and fire doors in the new year, and we might even have into what some of our states are doing around cladding removal as well. If you've got any other suggestions for topics, please feel free to drop us a line at webinar@ife.org. So a big thank you, round of applause to Tom and Luke. Thank you.